Morning, my name is Bruce Provan. I'm the Managing Director of Page Provan Family and Fertility Lawyers. We're a firm of lawyers in central Brisbane that practice exclusively in family and fertility law. I want to talk to you today about what happens to your assets in a divorce. The first thing to note is that the divorce is separate from the property settlement, and very often the property settlement happens before the divorce. The divorce is the process for dissolving your marriage, whereas the property settlement is the process for dividing up all of the assets and superannuation that are owned by you and your spouse or former partner. So the way assets are divided in a divorce, we talk about a 5-step process. Now this 5-step process has been sourced in the cases that come out of the court, and as lawyers we advise you about that process with the intention that we can try and resolve your matter without going to court. So the first step is to say, look, is it just and equitable for there to be a court order? In the vast majority of cases it is, because you will have combined assets or you may have children together. But in a small number of cases the courts have said that it's not just and equitable to have an order, for example, where a couple has kept all of their assets separate throughout a relationship. The second step is to say, right, what's the pool of property that's available for distribution? So in other words, what are all of the assets and the superannuation and the liabilities that are owned by you or your former spouse, or you're owned jointly, or they're in a trust or a company that is controlled by you and or your former partner or former spouse. And the next step then is to quantify all of those assets, liabilities and superannuation to come up with what we call the pool. The next step to work out how that pool gets divided is to say, what were the contributions? In other words, what did each of you contribute during the course of the relationship? Not only at the start of the relationship, but also during the relationship and following separation. Now, contributions is not only financial contributions. Contributions extend to other things such as homemaking and parenting, but it can also include other non-financial contributions. In other words, work that you might have done that didn't get paid for. So for example, if you did work to improve a house or one of your other assets, that can be taken into account as a non-financial contribution. So the process we go through is to assess those contributions, and then we generally say that the contributions should be assessed X% to one person and Y% to the other. The next step that we go through is to look at the future needs of each party. Now those future needs include a wide variety of factors, such as, are there children and who's the primary carer for the children? The age and health of each of the parties, their relative income. Has there been family violence during the relationship? Has either party cohabited? So there's a range of factors that get taken into account, and then we say that there should be an adjustment in favour of one person or the other. And once we've gone through that process and worked out what the appropriate percentage should be, is to have a look at how the property is proposed to be divided and work out whether that would be a just and equitable outcome. Now in the vast majority of cases, these matters are resolved through negotiation. It's only a small number of cases that end up going to court before a judge who makes the decision. So as lawyers, it's important for us to be able to advise you what the likely outcome is and what your entitlement is, and to try and negotiate with your spouse or former partner to come up with an acceptable solution to the two of you. My name is Bruce Provan from Page Provan Family and Fertility Lawyers.